I sit down with Miss Sonia Mathur, senior advocate, criminal prosecutor, worked with the biggest agencies, over 3 decades of experience in cases which are criminal, rape, murder cases, one of the biggest political cases. She's a mother, a wife, and a daughter, a brilliant lady, extremely soft-spoken. I navigate the aspect of criminal laws with her. I navigate her. Stay with me, Shweta Stockies with Sonia Mathur. Sonia ji, you have been a special prosecutor in the renowned 2G scam. We as the normal people get to hear it in bits and pieces, and then something changed and something didn't happen. Could you summarize for us your role in it, and how does one handle or go about with cases so massive as that?
See, so far as my role is concerned, I was assisting the lead prosecutor, who was appointed by the Supreme Court. And he was given an option to pick up some people to assist him from the CBI teams. And that was the time when I was a CBI counsel in Delhi High Court. Okay. So I was picked up by him, asked to assist him. And so I was the assisting counsel. But the experience overall was really phenomenal, got to learn a lot.
How do you mentally prepare for something like that, or does it come to you naturally?
I think it just, you are a part of it, and so it just comes along. You don't have to really prepare, because the focus mainly is on the evidence. Now this was a case where CBI had collected the evidence, and there were multiple people involved, politician, business, and so there was a lot of evidence which was collected by CBI. So to go through all the evidence, and the most exciting experience in the 2G trial was when one of the witnesses, who was very, very renowned, from a very renowned family, and it was put up that she was not in a position to come to Delhi and testify in the court. So on direction from the Supreme Court, the court was set up in their house.
Wow!
Yeah,
amazing.
So court was set up in the house. It was a direction from the Supreme Court. So we all, including all the defense lawyers and all the prosecutors, and everybody went to that particular town, and there we had court set up. So that was a very different experience.
Clearly.
Yeah.
But because we are the normies, we're the normal people, right? How much time, a massive case like 2G, what kind of a manpower, intel requirement is there to do what all? I mean, it must be evidences, it must be reading previous cases or something parallel to it, mentally preparing. What happens?
Oh yes, there was lots of work, and everybody, not only the prosecutors, even the defense lawyers, and everybody had put a lot of efforts, a lot of work. So it's difficult to define that, how much would it be, how much time it would consume a trial like this, because there was another hiccup in this case. The lead prosecutor was appointed as judge of the Supreme Court directly. So there was a slight vacuum created at that time. Supreme Court appointed somebody else in place of him to lead the prosecution. But that didn't cause much delay. But of course, this was one event which did
impact.
Not really impact, because competence-wise, I think both were a match to each other.
How do you mentally prepare yourself for something as massive? And I'm coming from a very personal viewpoint. I mean, for literally all the law students out there, and you'd be so lucky to do large cases like this. What's the mental preparation? How much of constraint, restraint, or budgeting one has to do?
See, you need, in any criminal case, I would say all criminal cases are predominantly based on the facts. The law comes later. One fact here and there can, you may rely on a precedent, you may rely on a judgment, but one fact here and there, it can make the precedent inapplicable. So therefore, it's more of the criminal cases is all about, they say that know your facts, know your law, know your judge, and know your opponent. This is what is usually taught. But in criminal cases, I think know your facts is the base. So you need to really, really know your evidence, know your limitations, also what you have and what you don't have, what you can try and prove before the court and what you cannot.
Another very large case, you were representing one of the respondents, is the now famous Bilkis Bano case. How complex was something like that? And what exactly?
Not really, because this was a case where, the early release, which in common man's language I can say early release, otherwise it's remission, was challenged. So my point was that the person that I represented, the whatever submissions I had made before the courts were only limited to the point that remission is a policy of the government, right?
Okay.
Which entitles me to ask for release after a particular period of time, after I've spent a specified period of time in prison. So after that, if I become capable of asking the state government to release me prematurely, then my case was that I have earned that. I have been good in the prison and I have earned that. Now, if there are some procedural lapses on the part of the government, the state government or the competent government, then I can't be the one responsible. So far as I am concerned, I have spent the specified period in custody, and as per the policy of the government, I'm entitled to ask for release. So, and particularly when I've already been released, and it's nobody's case that after having been released, I've done something which is, against the law. So my point was that I have earned release, I have earned remission. It's not a bounty which has to be given to me as a charity. I've earned it.
Fair enough.
Yeah.
Am I correct to say that out of, there were 13 and 11 were convicted? 13, something like that? Something, yeah, even. And there was an absolute uproar without people understanding exactly why it panned out the way it did, because it was simply following a rule. Could you talk a little bit about that? This is not a moral take for
social
you.
uproar is something which is, it's very difficult to sort of define that, what something may shake your conscience, may not shake mine. So this cannot be a governing factor for the courts to decide any point, because for that matter, there is one case, the courts have made this observation that, sometimes for lack of evidence, you have to let go of the person who's accused of the offense. It may cause a lot of pain in the society and greater pain to the victim's family. But then the cases are not decided on the basis of, social conscience. Now I'll tell you, I was doing a rape and murder case, and where I had e-mulaqat with the convict who was imprisoned in Madhya Pradesh prison. He was sentenced to death. He's waiting to be hanged. So I was doing his case. So I had e-mulaqat with him. Now, before I saw his face, I was doing my job. It didn't bother me at all. But when I had the e-mulaqat with him, that whole night I could not sleep. I just kept wondering that, what if? So social conscience is something very relative. So they were convicts. They had undergone their sentence, which was awarded to them by the courts. They had already undergone. So it's not that, they were let off in the sense, they would stay, even if they were granted early release, they would stay convict for the rest of their life. So it's not that the tag of conviction was taken away from them.
You were amicus curiae to the famed Chawla gang rape and murder. Your personal take on how you approached it versus how people saw it, conundrums, ethical questioning, how do you manage that? And how did you manage this one in specific?
See, I was appointed by the court as amicus, as you just said. So my responsibility was to assist the court in the best possible manner. And you're right, there was a lot of, even earlier, at the stage of investigation also, from what I read, there was a lot of media attention that this case had gotten. But for me, it was another case where I was to only assist the court with the evidence which was available on record. Now, in this case, the facts which were set up by the prosecution were that there were three boys and they had kidnapped this 19-year-old girl, and then her body was found 3 days later. They raped and murdered her, and the body was found somewhere close to Faridabad. So, and there were pictures taken which were part of the trial court record, picture of the body which was taken, which was quite moving, in that sense. But then, so far as the evidence was concerned, evidence was not really foolproof in that sense, especially to, convict somebody. Like there were witnesses which said that this girl was kidnapped in a red Indica. Nobody, just to start with, there are multiple things, but just to give you now nobody knew what is the number of red Indica. Nobody could identify the driver. Nobody could identify the boys who were stated to have sort of come out and pull that girl inside. So, red Indica car was too much to chase. There could be number of red Indica cars in Delhi, So this was one, just to start with. And then there were multiple things. In this case, the court also considered that they were not given a fair trial, because there were apparently 49 witnesses, and out of 49, 10 crucial witnesses were not even cross-examined. And the court did make some observations about the role of a trial court. That in a situation like this, when the effective cross-examination is either not done or there is no cross-examination at all, then can the trial court be a moot spectator and just let it happen? So this was also one of the reasons that weighed with the court to say that the trial they were not given a fair trial. And the DNA report, which actually connected the accused, the DNA report was, when you prepare the DNA report, there is some scientific basis on which you make the conclusion, right?
Okay.
So the conclusion was, the basis was not a part of the record, it was only the conclusion that it matches. There is some allele table which is made on the basis of which you come
What
to the
table
conclusion.
is it called?
Allele table.
Allele table.
So there was only the conclusion that it matches. Now the expert who had come was not cross-examined at all as to how, that was the stage where trial court could have called for the record. Called for the record and could have satisfied itself that yes, it has been done properly, the DNA matching has been done properly, but nothing of that sort was done. So the benefit of doubt was given, and in this case, judges have recorded that it may hurt the social conscience and it may pain the victim's family, but then we are bound by the evidence. So my job was only to place the evidence, however hard hard it may be on myself, but then at the end of the day, I'm doing my job, and I'm not the judge.
Correct.
I'm the lawyer. My job is to place the evidence before the judges, and it is for them to take a call whether to convict somebody or acquit.
What is the big impactful difference between an eyewitness and a circumstantial evidence? A lot of circumstantial evidence is used in a lot of cases, so we're thinking, okay, it was a part of the circumstance. Is that what it is? What is it exactly?
See, eyewitness is somebody who will say that yes, I witnessed the crime myself. I saw this happen, which is a very difficult piece of evidence to find in cases such as rape, especially. Because these are the offenses which are not conducive to that sort of an atmosphere. It can never happen if there are eyewitnesses. But and circumstantial evidence is when it's a circumstance which points towards you. It's like this, that supposing if somebody has been killed, and so there would be people who can say that yes, we saw this person we saw the deceased going with the convict, going with the accused. So that's a circumstance which points out that this person had access to the deceased, so he would know what happened to him. So that's a circumstance. So then the the investigating agency would look for an explanation for that from that person, that you were seen with him last. It's called last seen theory. Let me give you an example of a case of circumstantial evidence on a last seen theory, like Arushi Talwar case, where there was no eyewitness. Nobody had seen who had killed her, but in the house where she was killed, she was there with her parents. So parents were supposed to know that what happened to her. So, and as opposed to this, if it's an eyewitness, then the eyewitness testimony is put on a very high pedestal, and especially if it's somebody it's somebody related, then there are judgments, and the jurisprudence is then you have to test it in a little stricter manner if it's an interested witness. Even then, it's not to be rejected outright, but then if it's an interested witness, the testimony has to be scrutinized in a little stricter manner. But otherwise, eyewitness account is considered to be much more dependable in that sense. And but there is also a saying that a witness may lie, circumstances don't lie. Because and so therefore you can't sort of undermine a case which is supported only by circumstantial evidence. You can't undermine that. But at the same time, an eyewitness account is considered to be more dependable in that sense, especially if the eyewitness is able to stand the test of cross-examination.
As a woman now, if I ever found myself, God forbid, or anybody did, in a situation where I'm thinking situation can turn bad, or unfortunately I was, let's say for the lack of a better term, violated, in this case rape, right? First thing, from a law perspective, from making it official, going and getting justice, 1, 2, 3, 4 steps, what should happen?
Immediate thing is file a report.
To
file an FIR. Go to the concerned police station and make a report. Now, after the amendments, even earlier it was like this, the concept of zero FIR. That even if the concerned Thana would not have a jurisdiction, if somebody comes and complains, this is of course you're talking about yourself, but even if somebody else comes and complains about a cognizable offence, then FIR has to be registered. The police can't say that we don't have the jurisdiction. It's a zero FIR which is registered. So first thing you need to do is register an FIR, and the moment you do that, then it's the police which takes over. And then your medical examination is one. Then if you're able to, sort of identify, point out the person who's violated you, then if arrest is required of that person, then the investigating agency takes over. And then to add credibility, there is also a statement under 164 of the CRPC, the earlier provisions. It was recorded before the magistrate. So then the victim is taken to the magistrate and the statement is recorded. So further, it has more sanctity because it is recorded by a magistrate. So first thing is you need to report it to the police. Then thereafter, the police has the prescribed steps that they need to take.
If I put you in the living room of the victim before she goes and files and hesitating to do so, what would you advise her?
First thing, don't hesitate at all. Your bodily integrity, if it's been violated, I don't think there is any reason for the victim to hesitate at all.
The rise of digital evidences, how is it now impacting your cases, your trials, both criminal and otherwise? And how has it made it better, or has it just made it worse?
No, I think it's the digitalization of evidence is playing a very, very significant role in cases. Such as, I'll just tell you about one case where it's still pending, so I will not talk about the details, but the allegations are of rape in a hotel, and there's a CCTV footage which is reflecting absolutely otherwise. The mannerism or the body language of a rape victim as opposed to somebody who has had a consensual relationship with somebody is totally different. And it's, if in absence of the CCTV footage, etc., it's just word of the victim.
Oh, I see.
Right? There is nothing else. So the mannerism and the body language of the victim post the incident majorly reflects on what the victim has actually undergone.
So this footage was before the incidents or post?
Post.
Oh, it was the post the incidents. It's not a laughing matter, but I understand that. Are these? This is a very generic question, but I think quite poignant. Are these laws or provisions given often misutilized these days? Are they being misutilized?
They are misutilized. We can't say that, and another case that I had done where the allegations were of rape on a false promise to marriage. And later on, it was discovered that the victim, the alleged victim, was already married. So it's not that these provisions are not being misused, they are being misused. So therefore the courts also realize it, and they're a little more, circumspect and a little more cautious
About it. In Gen Z language, more sus about it. They're more suspicious about it.
Yeah.
We're sitting in 2024, and apparently there has been a lot of reforms or changes to the Indian criminal law system. Could you, in your language, explain exactly what changed before and after? Make it for the dummies, simplify the recent changes in the criminal laws.
So the main idea seems to be the decolonization of the laws which were made during British era. So this seems to be the idea behind changing the names of the three prominent acts. And apart from that, there are certain changes which are really, really welcome. And first one that comes to my mind is community service, because they've provided for community service now for the first time offenders, etc., which is really welcome step. And the other is that so far as the criminal trial and investigation are concerned, they are now time bound. It's not that it'll go on forever. And even at the stage of investigation, if somebody registers an FIR, then within 90 days the police have to inform the complainant about the status of the investigation. And the third thing which really sort of crosses my mind when I talk about the changes is that digitalization and the evidence now. There can be e-service of summons, there are e-summons which are served, and the evidence can be taken through video conferencing. So there is a lot of electronic
upgrades, interventions,
which is being used in the day-to-day conducting of criminal trials, etc., and also the investigation, which is really good. And then, of course, there is one provision about witness protection program. Every state has to have a witness protection program, which is...
It did not have that earlier.
It did have, but it wasn't really implemented the way it should have been. Where, now I'm really, really hopeful for this. And this is very important for the criminal justice system, that a witness who comes forward and testifies should have that sense of, protection or sense of security. And then in the definition of gender, now transgenders are also included.
Oh, lovely.
Which also is really nice, very welcome step, because, it's not that there were no offences committed against transgenders. There have been offences. It's just that in absence of data, we don't know. We didn't know because data is not there. So we don't know what is the frequency with which this class of the society is exposed to different offences. So with this, again, I think is a very welcome step. Inclusion of transgender in the definition of gender. Earlier it was only male and female.
One case in your career that really, really moved you or put you in a conundrum and really tested you?
So this was rape and murder of a 2.5-year-old girl. Yeah, this is, and 21-year-old was the convict, and the child was 2.5-year-old. So that really bothered me. I mean, it shook my conscience completely, and I really had to convince myself to try and to argue in favor of the convict.
Because
But
that was literally your job.
that was my job, and
Oh my
I
God.
had to do that. So anything other than that would have been in conflict with my job, you know. So I had to confine myself to the evidence, but this kept bothering me, you know, just the thought of a 2.5-year-old child being there.
What had happened, if you don't, I mean,
Yeah.
as much as you can?
Yeah, no, this case is over. So it was a 21-year-old boy. He had raped a 2.5-year-old girl, and she obviously died after that. She was taken to the hospital, and I think that's why she died. So then he was convicted and sentenced to death, but the Supreme Court had commuted his death sentence to life imprisonment, and 25 years was the sentence awarded to him with without remission, I think. So I mean, I could not get this child out of my head. You know, whoever could have been, you know, the accused, but the victim definitely was there. Even if I argued that, you know, in fact, I started with saying this, that this case shook the conscience of the society and also mine. But then what we need to see is the evidence. Is the evidence sufficient to point out to the person who we have as the convict? But so whoever could have been, even if I convinced myself to argue for the convict, the victim was definitely there. There was a 2.5-year-old child who was raped and who died. So thinking of victim was definitely, it was a toll.
Yes, yeah. Upcoming women lawyers, students, people who look up to you or want to be as soft-spoken and fully a criminal prosecutor, what would be the words of advice you'd give them? And actually cut the flag. Don't mince your words, but say it as it is. Is it easy to navigate? You did mention you had never really faced prejudice as a woman. You always were respected by the system. Comment.
So far as I'm concerned, it's a fact that I did not face any prejudice because of being a woman. And I got my share of respect, encouragement, whatever was my due, I got from the system. So far as advice to the younger lot is concerned, it is, I think it's the hard work, and there are no shortcuts to the hard work is one. And second is, don't make compromises where your heart doesn't allow you to. There are certain handicaps which are bound to be there because of you being a female. So,
Such as, for example?
such as, like, you know, I was a prosecutor. I was interacting with the officers all the time. But then for me, it was only work, right? I couldn't sort of, you know, have any other conversation with them.
Like a
Then,
buddy mode conversation per se, which
Yeah.
they can enjoy once in a while.
Right. So that is one thing which was there. But then I don't think I took it as a handicap. Maybe you need to walk a couple of miles extra to match. But I don't think, if you're hardworking,
It shows.
it shows.
It works.
Yeah, it works. At the end of the day, it does work.
You always wanted to be a criminal lawyer?
No, I'm not, of course, I have now been sort of branded as one, but
Yeah, your cases.
but I started with, I was a tax lawyer. I was,
Oh.
yeah, I was representing the income tax department in
Oh.
Delhi High Court for a very long time.
You also have a cricket team, which
Yes,
I
I do.
recently unearthed.
So not one, I have two.
You have two cricket
one
teams.
is men and one is women.
And you're passionate about cricket.
Yeah.
How did that happen? I mean, did you go for it like by yourself? Like, I am doing this. Or did something trigger it?
No, nothing triggered it.
You were passionate about cricket?
Yeah, it's just that I thought of doing it, sponsoring it. I think, if I'm not wrong, I was the first women senior lawyer to sponsor a men's team in Supreme Court. And then I had the women's team approaching saying, why are you not sponsoring a women's team? So last 2 years I have been sponsoring even a women's team, and they have been giving me trophy.
Has your husband ever succeeded in prosecuting you in a fight? I want to know this.
He's a doctor, so can't be a match.
Can't be a match.
Can't be a match in arguing.
Your daughter is a lawyer.
She's a
how
lawyer
does that
married
feel?
to a lawyer.
She's a married lawyer. We don't want to mess with this family. Sonia ji, thank you so much for your time. I should have taken law earlier so that nobody messed with me either. But absolute delight. Thank you for the weight you carry and service. Looking forward to more wins for you. And
Thank you very much, Rita. It was a pleasure interacting with you, pleasure talking to you.
Thank you.
I really want to compliment you on your mugs.
Oh, my mugs. Thank you. Thank you so
Cheers.
much.
Thank you.